Hello, today is Thursday, November 12th, 2020. I'm Joe Schmidt from TC2, and this is Staying Connected. On these podcasts, we cover an array of technology topics, and when we discuss regulatory matters, well, I suspect some listeners probably squirm a bit, worrying if they're doing the right thing, and rightfully so. On past podcasts, we've discussed why enterprises can't ignore the net neutrality debate. We've highlighted how regulatory fees like USF are killing your telecom budget, and we've alerted you to the new initiatives to curtail robocalls. And undoubtedly, a couple of the most important regulatory subjects that we've been covering include the California Consumer Privacy Act, CCPA, and we warned that the EU's GDPR is a big deal if you do business in Europe. Today, we will look at another EU regulatory issue known as Schrems II. And to do that, I'm joined by two of my colleagues from LB3, Deb Boehling, a partner, and Patrick Whittle, who is of Counsel. Hey guys, thanks for joining me today. So, Deb, what's this Schrems II thing all about?
Hi, Joe. It's good to be back on Staying Connected. Schrems II is a court decision affecting ways in which companies comply with the GDPR that you mentioned in the intro. Fines for violating GDPR are enormous.
So, Patrick, what did companies do before Schrems II?
Joe, before Schrems II, and thanks, by the way, for having me, there were basically three ways for companies doing EU to US data transfers to comply with the GDPR. The first was based on an adequacy finding by the EU that the so-called Privacy Shield adequately protected European citizens' personal data under US law. The second one was the use of standard contractual clauses that had been drafted and issued by the EU that were a safe harbor for companies making the data transfers outside the EU. The third was a set of binding corporate rules that would protect transfers between affiliates in different countries, the one affiliate in the EU and the other outside. We won't discuss that one today because I think that's less relevant to the folks listening. In this case, brought by a privacy advocate in Europe named Schrems, interestingly enough, the Court of Justice for the EU invalidated the Privacy Shield. It struck the previous adequacy finding that had said the Privacy Shield was adequate under European law to protect European citizens' data, so that any company that was relying on the Privacy Shield and self-certifying that it complied with the Privacy Shield could no longer do that for purposes of complying with European law when they transferred data from Europe to the US. The court also raised questions about the adequacy of the Standard Contractual Clauses, aka the SCCs, in the context of transfers to the US because the court found that the US governmental authorities had too much potential access to that data without adequate legal protections for EU citizens. This means that the EU to US data transfers that relied solely on the Privacy Shield are now illegal under EU law, and those that rely on the SCCs may be illegal. And we'll get to why that is in a minute. But bottom line, if you purchase telecom and technology services that involve EU to US data transfers, you must take steps to come back into GDPR compliance.
And the case-by-case determination for the U.S. that Pat mentioned may be difficult. In Schrems II, Privacy Shield was invalidated because under Section 702 of the Foreign Intelligence Surveillance Act, U.S. surveillance is not limited to what is strictly necessary and proportional for U.S. national security and law enforcement interests. And, as with Executive Order 12333, EU subjects lack an effective legal remedy to challenge disclosures to authorities. The same questions are likely to arise when SCCs are used for EU to US transfers.
So let me see if I get this. Privacy Shield is not good anymore, but the Standard Contractual Clauses, those SCCs, those remain valid for EU-US transfers. Is that right?
Yes and no, Joe. The SCCs do remain valid in principle, but because of the court's decision, a case-by-case analysis must be performed in any given situation as to whether they provide adequate protections to European citizens' data or whether additional protections must be agreed to. And remember, that has to be done quickly because the EU order was effective immediately.
So, Deb, where does LB3 come down on this?
We suspect that U.S.-based multinationals can continue to use SCCs only with additional protections. So companies should be prepared to show that access to the data is strictly limited to what is necessary, and EU subjects have an effective legal remedy that is an actionable right before U.S. courts. The latter may be difficult. Based on our experience, U.S. headquartered multinationals rely on EU to U.S. data transfers for their business. Replicating necessary operations in the EU to prevent transfers of EU citizens' personal data is costly and time-consuming. So I suspect EU to US transfers will continue, but those transfers pose risk.
And exactly how great are those risks?
So, Joe, for our US-based multinational clients who seek our assistance in purchasing telecom and technology services, the risks are significant. Particular risks apply when your supplier is an electronic service provider, which is widely defined to include companies like Verizon, AT&T, CenturyLink, Amazon, Google, Microsoft, virtually any technology, telecommunications, or cloud provider. Well, and why is that? Well, it's because the EU court was primarily concerned with the broad scope of disclosures that might have to be made to the U.S. government under U.S. law by those providers under the laws that Deb mentioned. And these are, the court found, without adequate legal protections for EU citizens.
So to address concerns about access to the data being strictly limited to what is necessary and providing EU subjects an effective remedy, some or all of the following appear warranted. In your contract, require your vendor, and these vendors, as Pat had mentioned, the electronic service providers, to maintain and use EU citizens' personal data only within the EU and prohibit them from transferring it to the US. That's possible where you're working with ECSs that have international operations. May be tough. If that's unsuccessful, though, you need to take precautions to minimize the transfers of personal data to the extent necessary to conduct your business, and encrypt it with a very strong encryption key that is not supplied by or shared with the vendor.
So, Deb, what else can be done to keep your vendor in check?
In your contract, prohibit the vendor from accessing or attempting to access any content transmitted over their service, unless such access is strictly limited to the data necessary for them to provide you the service. You should also prohibit the vendor from attempting or allowing others to attempt to decipher encrypted traffic, and try to remove any exceptions from these requirements and confidentiality obligations for disclosures under Section 702 of FISA. Even without the specific exceptions, understand the relationship of the requirements with a vendor's obligation to comply with laws. Obligate your vendor to resist governmental requests under FISA, and most importantly, provide you notice of and a right to suspend or terminate the contract if the vendor is unable to maintain compliance with the Standard Contractual Clauses or the additional data protection contract requirements. Since your telecoms and tech vendors are likely subject to FISA, you may also want your vendor to provide transparency reports on its FISA requests with accounts affected and the total number of accounts it has, and do that on a routine basis. This may help you show the practical risk of the disclosure is low. Outside contract, you should analyze the practical risk of access to personal data by U.S. governmental authorities by looking at those transparency reports. The Department of Commerce December 2020 white paper entitled Information on U.S. Privacy Safeguards Relevant to SCCs and Other EU Legal Bases for EU-U.S. Data Transfers After Schrems II. That's a mouthful. If you want more information, get in touch with us. But that document also provides arguments to show that the U.S. law, as it exists today, provides adequate protection to companies relying on the SCCs and adequate protection to EU subjects. But bear in mind that this white paper is not binding on the EU.
And whatever you do, there's going to be risks because of the unknown, Joe. Doing the things Deb described will reduce the risks. As she says, the Department of Commerce is trying to minimize those risks. But frankly, that paper reads to me like an effort to relitigate the court decision. As she said, it's not binding. In the meantime, the European Commission is working on updating the Standard Contractual Clauses to address the concerns raised by the Schrems II decision. And the EU has just today released draft updated SCCs to address some of the issues that we've talked about. Those are subject of public comment and final approval. Final approval is expected in early 2021. On a first look, those draft updated SCCs are consistent with the guidance that we're giving you on this podcast today. But of course, Schrems, being a strong privacy advocate, may challenge these as well. And his ultimate demand is that U.S. law be changed.
Okay, thanks, Patrick, and thank you as well, Deb. This really is interesting and definitely something multinationals better be on top of. Now, if this has you thinking you better get up to speed on Schrems II, and you'd like to discuss it with Deb or Patrick, or if you have other regulatory concerns, you can contact the two of them or any of us at LB3 and TC2 by calling us or dropping us an email. You can also stay up to date by subscribing to Staying Connected, checking out our websites, or by following us on LinkedIn.